Motel Incorporated Appellant versus United States et al. In this case, probable jurisdiction is noted. The joint motion for acceleration of oral argument is granted, and the case is set for oral argument on Monday, October 5th, 1964. We will proceed. Mr. Rolliston.
Mr. Chief Justice, may it please the court.
Is this your only brief, one joined with the jurisdictional statement?
Yes, Your Honor.
Thank you.
The court instructed us to file the brief at the same time we filed the jurisdictional statement. It's the only brief on either question. This is an appeal from a final judgment in the United States District Court for the Northern District of Georgia, Atlanta Division, which was heard before a three-judge court on a complaint filed by the appellant herein, who was a plaintiff below, seeking to declare the Civil Rights Act of 1964 unconstitutional and seeking a permanent injunction against the United States and the Attorney General of the United States at that time, Mr. Kennedy, from enforcing that act against the appellant. The government filed not only an answer but a counterclaim, and in the counterclaim asked for an injunction under the provisions of the Civil Rights Act against the appellant. The case was heard and decision rendered on the counterclaim of the government, and the permanent injunction was granted against the appellant and any officers or agents acting for it.
Did you initiate your suit before a single district judge?
Your Honor, we filed the suit in the United States District Court. It was actually received by Judge Hooper, and Chief Justice of the Fifth Circuit, Elbert Tuttle, convened a three-judge court on his own motion.
That was on the certificate of the government. The case was a public importance in the three-judge court.
The government filed such a certificate, but I was under the impression Judge Tuttle convened the court himself. Before even the answer was filed, yes. Now, the facts in this case are very simple. As a matter of fact, parties in the case tried to make them simple. They are made by the pleadings and the answer to the pleadings and a short stipulation of facts, and these generally and briefly are the facts. The Heart of Atlanta Motel Incorporated is a Georgia corporation that owns a motel in Atlanta named the Heart of Atlanta Motel. It is the only business that it operates. It's the only business it has in Atlanta. The motel has 216 rooms. It's located in downtown Atlanta and fronting on an interstate highway. By stipulation, we agreed that over 75% of all the business in the form of guests come from out of the state of Georgia, that most of the convention business is solicited out of the state of Georgia, that we have highway billboards on roads in Georgia. There was nothing in the stipulations about a restaurant because we brought the suit in the name of the corporation. The restaurant in the motel is operated by a lessee. The government in their counterclaim included the lessee, but later dismissed them because they determined as a matter of fact after the passage of the act the lessee was complying with the act. But the lessee of the restaurant was complying with the act. They are a lessee in our premises. It's somewhat important in the case because also the Alabama case following this one, there is a restaurant involved, but not in this particular case. But the law applicable is interesting and applicable to us because eventually it will apply to our restaurant too, even though it's a lessee. And I think those are all the facts. I think it comes squarely under the law as proposed by Congress. In fact, Now, we have attempted to and have attacked the constitutionality of Title II of the Act, which is the public accommodation section. Although our petition, to make it perfectly clear, says that the Act itself, the whole Act, will fall for the same reason we think Title II will fall. Now, Title II of the public accommodation section has really got two parts that making a difference in this hearing. The one that applies to motel just says categorically that all motels and all hotels affect interstate commerce. They do it in a devious way. They say that these establishments listed hereinafter which affect interstate commerce are covered by this Act. And then in a subsequent paragraph, list motels as well as a lot of other things. And then they say anybody listed in the above paragraph therefore affects interstate commerce and therefore is covered by the Act. But in substance it says every motel in the United States, all 60,000 of them, are part or affect interstate commerce. The other part of the Act, which I referred to a minute ago about a restaurant, says that a restaurant that serves or offers to serve food to an interstate traveler, or who serves food a substantial portion of which has already moved into interstate commerce, is covered by the Act. There is a distinction because the restaurant is a factual situation. It's conceivable that you could find in favor of a restaurant in this case and against a motel, but not vice versa. Because I believe each restaurant will stand on the factual situation of that restaurant, whether it serves interstate commerce travelers or whether a substantial portion of food passes in commerce, is already passed in commerce which they use, if those theories will stand up. But as to a motel, the portion that we are primarily interested in is the portion that says that all motels, regardless, are part of interstate commerce, are affected.
Is the word motel defined in the Act?
No, sir. It lists motels, though, and lists hotels in the Act.
No definition of what a motel is, or isn't?
There's the only exception, which doesn't apply, of course, that if it's a building that the owner lives in and occupies as a residence, only 5 rooms are rented, then that's not part. That's not a motel. Now, may it please the court, this case has gotten here in a hurry, and I'm not sure how much of the briefs the court has had an opportunity to look at. And in the short time allotted me, it'll be hard to cover it. And I want to take this amount of information, approximately half of my time on direct and about a half of it on rebuttal. There are 5 theories of law that we rely on in this case. Number one, that the law of the land, and any lawyer is delighted to have a white horse case that says what the law of the land is, if it's true, is our first one. That is the decision of the civil rights cases, which was upheld by this court in 1883. The second proposition, yes, sir. A white horse case is the one that just fits your case exactly. He doesn't have a red head or black tail. He's all white and he fits the whole case precisely.
We used to call that a blue bottle case, I don't know.
We know what we're talking. The second proposition is that the 14th Amendment, neither the 14th Amendment nor the Constitution, prohibit racial discrimination by an individual. The third proposition, we contend that the Civil Rights Act is an unlawful extension of the power of commerce under the Commerce Clause. Number 5, we contend that the Act, the Civil Rights Act, violates the 5th Amendment of the Constitution, and last, that it violates the 13th Amendment of the Constitution. And we submit, gentlemen, that if we can prevail on any theory, any one of those 5 theories, then this Act's got to fail. Why the Act was passed, what the morals or the reasons or the legislative intents or purposes were, is a matter for the people on the other side of the square across First Street in Congress. I will not touch on those, maybe except in rebuttal. But we're in a court of law, the highest court in this country. And I submit that the only thing really that's to be decided here is whether the people in Congress had the right under the law to pass this Act. The fundamental question, besides the legal question of the constitutionality of the Act, the fundamental question, I submit, is whether or not Congress has the power to take away the liberty of an individual to run his business as he sees fit in the selection and choice of his customers. This is the real important issue. And the fact of alleged civil rights of the Negroes involved is purely incidental. Because if Congress can exercise these controls over the right of individuals, it is plausible that there's no limit to Congress's power to appropriate private property and liberty. Theory number one. The Congress passed an act in 1875 which is almost identical to the public accommodation section of this act. And in 1883, this Supreme Court held that that act was unconstitutional. Upon the lengthy decision that the 14th Amendment did not prohibit racial discrimination by an individual where there was no state action involved. And let me hasten to say that there's no state action in any way involved in this case. This case was brought 2 hours after the President signed the bill. The state has nothing to do with it. They did not file even a friend of the court brief, as did 5 other states. And I didn't ask them not to. They have one just like they had in the Maryland case decided here in June. An individual under that state statute can seek a remedy under the statute. It is not being applied, and it's been made a matter of public notice that the state and the city of Atlanta will not apply it themselves. Been publicly informed. Actually, the state doesn't apply it except in the form that we file. An individual has to swear out a warrant for someone violating the statute, and then you'll be tried in state courts. Similar, almost exactly the Maryland statute y'all consider here in the Bell versus Maryland case. In the 1883 decision, which under the American jurisprudence is the law of the land until this court overturns it, they held that the similar act was unconstitutional. Now, it is true that in 1913 the Butts case came along and said, well, they didn't talk about Commerce Clause at that time. But I don't see how you can get around the language of the court in that case when it said that, of course, no one will contend that the power to pass this act, that Civil Rights Act, was contained in the Constitution before the adoption of the 14th Amendment. They started off the opinion that way, said there wasn't no doubt about it. Until we got the 14th Amendment, you couldn't pass such an act to restrain an individual or prohibit him from exercising racial discrimination, as long as the state wasn't involved. It is my contention that any Supreme Court, when a case comes before it, it doesn't make any difference what the people thought that enacted the law, or what was the theory of the people who argued the case before the court. The court has to look at the Constitution as it stands and any amendments to it, and regardless of whether we have to say anything about them as counsel, to consider the pros and cons of a case and apply the law as it is, not how it is argued or how the people in Congress thought it should be. I've been in the Supreme Court of Georgia many times where they decided a case that neither of us, neither counsel, even ever mentioned the theory in which they decided. And so in the civil rights cases, it is my contention that the court at that time knew that the Commerce Clause was sitting there in the Constitution. It had been there almost 100 years. And when it decided the case, and simply after saying, of course, nobody thought it was constitutional before it passed the 14th Amendment, then they said the 14th Amendment did not help it out, and that the act was still unconstitutional.
Didn't the court put the Commerce Clause expressly aside in connection with one of the defendants?
In that case?
One of the parties, yes.
No, Your Honor, I think all they said was that this was not raised in that case. As to whether it was applied to put it aside as to one of the defendants, I don't know. But I'd like to read two portions. I know the court doesn't like to hear reading much, but of this opinion, because it is, I think, a fundamental opinion that the court's got to consider. And this is a quote. If this legislation is appropriate for enforcing the prohibitions of the amendment, the 14th, it is difficult to see where it is to stop. Why may not Congress, with equal show of authority, enact a code of laws for the enforcement and vindication of all rights of life, liberty, and property? Civil rights, such as are guaranteed by the Constitution against state aggression, cannot be impaired by the wrongful act of individuals, unsupported by state authority in the shape of laws, customs, or judicial or executive proceedings. But the wrongful act of an individual, unsupported by any such authority, is simply a private wrong. To pass on to my next theory, that's right, John. That's true, Your Honor. They did in the lower court, but it's interesting that they changed their approach to the case in this court. As a matter of fact, it was stated by Mr. Burke Marshall in the lower court that they did rely on the 14th Amendment in open court. But in the briefs in this court, it's not relied on. And they also backed off from two other theories, which I'll mention in a minute, which they did not. They have relied strictly on the Commerce Clause in this case, it seems to me, in that brief. All I'm saying is that in the open argument in the lower court, they relied on it. In their brief, they said they rely on a single question, and that is whether or not the Commerce Clause is sufficient to give the Congress power to pass that. That's true in that brief.
Doesn't contain all the argument in the lower court, is that it?
I'm sure it does, Your Honor. Verbal argument. But I think
well,
Mr. Justice Goldberg is referring to my brief on page 15. Yes, I'm sorry. No, sir, because they have made the statement in the brief, as in this case right here in this hearing, that they stake their claim, and that's the words they use, on the Commerce Clause.
But according to your position, of course, all the issues are open here.
I don't think.
Just a moment ago, you said.
Yes, I don't think anyone can limit this court to what issues the court will consider. Just because if they wish to stake their claim and stand or fall on one theory, that's their privilege. We've got 5 we think we can stand or fall on. Anyway.
Is that privilege?
Well, sir, they have taken that
Suppose
position.
Congress had relied expressly on the 14th Amendment, and its act had been defined in such a way that it relied on the 14th Amendment. Could this court hold the law unconstitutional because an argument was made that the litigant was only depending on the Commerce Clause?
I think this court has the leeway to consider any portion of the Constitution at any time in any argument. I don't think either.
That'll support the act.
Yes, I don't think Congress can limit the court as to what they tried to base the act on.
I presume Congress could define it in such a way as to show that it only intended to rely on the Commerce Clause.
Yes, Mr. Justice
And
Black.
it was limiting it to cases that would come under the Commerce Clause.
But, of course, the Constitution is a document of delegated powers originally, and then by amendments they have added things that were prohibited both either to the states or to the Congress or to the national government. And if any one of those delegated powers would make the act constitutional, then it would be, unless it was prohibited by one of the prohibitions in some of the amendments. I think most of the prohibitions of powers are contained in the amendments.
I follow you on that. But let's suppose that the Congress had specifically stated in its law, we are exercising this power under the Commerce Clause. We wish its scope to reach no further than the Commerce Clause would reach. Would you say then that it could be decided on anything except the Commerce Clause?
Yes, sir, because we're not bound by what Congress thinks is the way to pass an act.
But we would be bound by what it passed, would we not? And if it passed one saying that we want this to reply to nothing except goods that are shipped in interstate commerce or that would come under that clause, would we not be bound by that?
Your Honor, let me put it this way. Suppose they said that this act is based on X, Y, Z, forget the Commerce Clause, and this act puts a man in jail without any trial, without a trial by jury or even any trial. And we say that this act is based on X, Y, Z in the Constitution. Can Congress violate a man's constitutional right by saying we'll base it on something in the Constitution that we alone will pick out and the Supreme Court of the United States can't overturn us? I say no. I say the court. Sir?
Do you think that's an analogous argument?
Maybe not, Beaver. I hope to make it there.
Well, Mr. Allen, I just meant to ask you this question because you've been arguing the 14th Amendment. Do you think that Congress did rely on the 14th Amendment, or that its definition of what shall be the crime is limited to a violation of the Commerce Clause?
Looking at the record, may it please the Court, the Attorney General at that time, in 63, before the hearings in 64, urged the Congress to limit this act to those fields in which there was an established jurisdiction or established power of Congress under the Commerce Clause. But in the hearings in 64, there was very little of that, and most of the things cited in the brief pertain to the hearings in 63. Now, the reason I mention that is because it is our contention, as I hope to get to, that there are no legislative findings of fact in this case, and there are no standards set up by which to determine in the Motel instance where a motel is subject to this act.
Converse, I gather you're suggesting that if we can't, that the government might rely on both the Commerce Clause and the 14th Amendment. But suppose it were the converse. May the government rely on the Commerce Clause without some indication that Congress, in fact, exerted the commerce power in the enactment of this statute?
Well, may it please the Court, I don't want to try to limit the Solicitor General to anything except what he said in his brief, but that is all he has said in his brief, and I don't think he can.
Well, as I read the brief, the government's made a demonstration, or at least attempted a demonstration, that in fact it affirmatively appears that Congress did rest this statute on the Commerce Clause. Do you disagree with that?
I can't find from the statute itself, unless we're just talking about strictly the public accommodation statute, that anything to the contrary to that, because they say that a motel has got to affect commerce and therefore so-and-so, and a restaurant which serves interstate commerce, and therefore they were obviously hitting at interstate commerce. And I think that's what they did, because surely they were advised, and I know they were in the hearings, of the existence of this 1883 holding, and I'm sure they shied away from the 14th Amendment at that time.
Well, then your position is that indeed, in enacting this statute, Congress did exert a commerce power.
Well, I'm sure they attempted to. I'm not sure that they said they limited themselves to that, though.
Testimony.
There is a reference, in substance, a reference to the 14th Amendment, yes. I think so. I think the Court can consider any part of the Constitution or amendments thereto in deciding anything that comes before this Court. And neither Congress nor counsel of either side can limit this Court in its consideration. Yes, sir.
It's perfectly clear that the government is arguing only that this act is, in this case, is arguing only that the act is constitutional, the constitutional exercise of the Commerce Clause. That's all we've got. This other debate may be interesting, but it isn't going to answer this lawsuit.
I'm just attempting to answer the Court's question, John. That's right. I agree with you. I think there are other issues that the Court will have to consider besides the contentions of the Solicitor General, of the 5 different theories that we are proposing. And one, a very simple one, if it's the law of the land, it's still the law of the land until this Court changes it. They had to, because the Commerce Clause is in the Constitution. They had to consider the whole Constitution when they decided. Yes. That is my position, Mr. Cheskover. In the case that was decided in this court handed down on June 22 of this year, in Bell versus Maryland, there was a Maryland trespass law, or anti-trespass law, involved, and of course the court really just sent the case back to Maryland for further decision. But the opinions in the court written by 3 judges on each side, what it amounts to, really point up a lot of my argument in this case. Because in Mr. Justice Black's decision that was joined in by Mr. Justice White and Mr. Justice Harlan, you 3 justices have said in substance that the Constitution, including the 14th Amendment, did not prohibit an individual from practicing racial discrimination, unsupported by any state action. Of itself. And that is this case exactly, a private individual elected to refuse to serve and refuse to participate or obey the Civil Rights Act in order to bring the Declaratory Judgment Act.
With one difference.
Yes.
That is, since that case was decided
Well, I realize that, John.
private property are certainly not strictly protected by the Constitution. They're subject to a valid exercise, A, of state police power, and B, subject to a valid exercise of the common power of Congress. And the question here is whether this attempt to affect private property rights through the exercise of federal power under the common law is a valid exercise of that power.
That's right,
So
Major.
that you, I think to me that you could devote yourself to the question as to whether this is a valid exercise of the common power.
Well, may it please the court, I'm really planning the last half hour of this thing to talk about commerce because I want to try to cover these other theories, which I contend that any one of them is good. The act will fail on those as well as the Commerce Clause. Of course, if the Constitution does not prohibit racial discrimination by an individual, unsupported by any other act, and I grant to the court that this Civil Rights Act was passed after this decision in June of 64. But if the Constitution and the 14th Amendment don't prohibit it, and Congress gets all of its power to enact any legislation from the Constitution, how then can Congress pass an act which will prohibit racial discrimination by an individual? Article 6 of the Constitution says the supreme law of this land is the Constitution, laws passed pursuant to it, and treaties. Now, Congress can't pass any law that's not pursuant to some delegation of power under the Constitution. One of them could be the Commerce Clause. Or they can't do anything that is prohibited by the Constitution. And the opinion that I just referred to, which is the dissenting opinion, said that the Constitution and the 14th Amendment of itself precisely did not, without state action, prohibit racial discrimination by an individual.
It did not refer at all, did it, to what Congress could do under the 5th section of the 14th Amendment and under the necessary and proper clause of the Constitution.
Mr. Justice Black you made it very clear in the footnotes that that's exactly what I think you intended to say.
Mr. Rawlinson,
Yes.
you've indicated that you don't intend to get to your argument on the Commerce Clause until rebuttal. Don't you think that inasmuch as you both agree that the thrust of this case is under the Commerce Clause, and as much as you're the top side of the case, that we ought to hear your argument on the Commerce Clause before we hear from the Solicitor General?
As Chief Justice, I'd be glad to accede to the wishes of the court. If I may comment on the 13th Amendment briefly.
Yes, you may, of course.
I will cover in brief theory my theory of the Commerce Clause and come back for the final on the button. The 13th Amendment simply says that neither slavery nor involuntary servitude shall exist within the United States. Now, 50 years ago, this court, in the case of Hodges versus United States, held that involuntary servitude was denounced by the 13th Amendment as a means of condition of enforcement of compulsory service of one to another. And while that cause, meaning the 13th Amendment, incited that amendment was the emancipation of the colored races, it reaches every race and every individual. And there have been other cases which have held that if a person is forced to serve another in business ways, that if that involves involuntary servitude prohibited by the 13th Amendment. I've cited cases in the brief, and I won't read them, of course. But all of these cases go to service contracts of one person performing services in business for another. And our Fifth Circuit Court in 1944 held that even if that person was compensated for it, unless the compensation itself constituted a waiver of their objections, that compensation itself for involuntary servitude still violated the 13th Amendment. Of course, there are exceptions to it. There's been held in this court that involuntary servitude does not mean service in the armed forces, although there are many buck privates who disagree with that. And they have held that service of a term for penalty for a crime, of course, is not involuntary servitude. But there are 8 cases cited here in the United States Supreme Court. There's a Fifth Circuit Court case and a Seventh Circuit Court case, and a case in one of the state's Supreme Courts which have held that service of another against his will in a business it constitutes involuntary servitude, which is prohibited by the 13th Amendment. Now may it please the court as to the Commerce Clause. Mr. Justice Goldberg made probably one of the most profound statements about the Constitution that I've ever read, in which I'm not sure that a whole lot of lawyers in this country would agree with me or even with the justice at this time, but I think it's still true. In the Maryland case, to quote Mr. Justice Goldberg, our sworn duty to construe the Constitution requires, however, that we read it to effectuate the intent and purpose of the framers. Not the framers as if they were sitting in this room today passing judgment on what the Constitution is supposed to be, but what the framers intended the Constitution to be at the time they adopted it in 1787. If that theory is not so, then the Constitution is just like any other law. It can be changed from day to day by the Congress and by the courts. The difference between our government and any other government in this world is that we have a Constitution that stays a Constitution in the words that it's there, unless it is amended by in the way the Constitution provides. Our Constitution is still the same Constitution it was in 1787, except the amendments that the people have decided should be added to it. When this Constitution was adopted, the United States was broke. We were in the middle of a depression as we know it, of financial chaos. The securities of this country were they were selling for 15, as a matter of fact. New York State and New Jersey State were fighting a trade war between each other. The Potomac River right out here was the subject of dispute between Virginia and Pennsylvania and Maryland because of tariffs and restrictions placed on trade. And the reason the Virginia Assembly called the convention, called an Annapolis Convention, was to talk about trade. There weren't but 5 states there, so they said, let's go back and get everybody here, and they called the next one in 1787, which was the Constitutional Convention. And the subject of that convention was some way to prop up the United States financially, because trade between the states was not going well, and that was the real chaos that we were having. And there is the basis of the little old innocuous clause in the Constitution which says that the Congress shall have power to regulate trade among the states. The best analysis, not in my opinion, but of historians, the best analysis of the Constitution and the reasons for its adoption and why it was adopted is found in the Federalist Papers. And in number 11, Alexander Hamilton defined commerce as the free circulation of commodities, period. And in number 42, James Madison, the other of the triumvirate, stated a very material object of this power of commerce clause was the relief of states which import and export through other states from the improper contributions levied on them by the latter. Were these are limited to regulate the trade between state and state, it must be foreseen that ways would be found to load the articles of import and export during the passage through their jurisdiction with duties which would fall on the makers of the latter and the consumers of the former. So what does that mean in our case? we say that the framers of the Constitution intended to cover commerce as commerce is known in business fields. And that is, it was intended to cover the transportation and movement and production of articles from agriculture, products of industry, methods of transportation, tariffs between states, which we don't have now, thank goodness, and anything else that had to do with commerce. But as the Birmingham justice in his case recently said, Tennyson's Brook, unlike Tennyson's Brook, commerce has got to come to an end somewhere, and it ends sooner or later in a state. It can't go on forever. And commerce means, as the framers of the Constitution intended it to mean, the only thing they thought about at that time was actual goods and commerce and the transportation of thereof. Now, it's true that Congress and decisions of the Supreme Court have enlarged the commerce power beyond which I submit the framers never intended and never thought it would be. And in this case, it is significant that the commerce power in the three big fields that we usually refer to, in antitrust and wage and hour and labor, in all three of those fields, Congress set up some standard. In the antitrust field, you've either got to be in interstate commerce or materially affected. But it leaves to the courts the determination of whether a particular business is in interstate commerce. It doesn't say Congress, as a matter of fact, can say of its own accord that every business is subject to antitrust laws. In the wage and hour field, no business is subject to interstate commerce, generally speaking, unless it has a certain volume of business, and they even have 2 or 3 different standards of that. But not every business is subject to wage and hour laws. As a matter of fact, the motel and hotel industry is specifically excluded from it at this time. And in the labor field, not until just very recently, in the hotel employees case, when the Supreme Court said to the National Labor Relations Board, you cannot exclude as a class all hotels or motels from your jurisdiction.
We're talking here about, aren't we, about a person moving in interstate commerce?
Yes, sir.
Driving from Virginia to Atlanta and asking accommodations for a night. Now, that is in interstate commerce. That person is moving in interstate commerce. You don't treat in your brief that point precisely. As I read your brief,
I do have a reference, Your Honor.
You don't refer to the Mann Act cases.
No, sir, because I don't think that's applicable. But even though they use the Mann Act under the interstate commerce, actually,
you say people are not commerce.
There is a holding of the United States Supreme Court that says that people are not commerce. People engage in commerce. People take part in commerce, but people themselves are not commerce. And it's so been held by this court and never been overruled. And, of course, that is a mighty good case to rely on.
Which case are you referring to?
It's the mayor, etc., the city of New York versus MILN, Mill, cited in this court, and it's in my brief. But the Supreme Court in that case held that people were not part of commerce. They engage in it, but they're not part of it. And certainly the framers in putting that one clause in the Constitution didn't include or intend to include people at that time. But the reason I made the analogy with the labor cases is that not every motel, not every hotel is subject to the rulings of the jurisdiction of the National Labor Relations Board. All the court has held is that the board cannot exclude them as a class. They look at each case to decide if that particular operation or organization is interstate commerce or materially affects interstate commerce, just as in the other cases of wage and hour and antitrust. So we say that in this case, the means adopted, the Commerce Clause, if you have it, to the end, and the end desired have no rational relation. There's no connection between the two. They have simply, after being advised of the civil rights cases in 1883, it seems like, have said, well, we can't find anything else in the Constitution to put this on. Let's put it on the Commerce Clause. We've been able to get away with so much else with the Commerce Clause already.
Well, what do you do with the difference of
The AAA case, Your Honor? I don't think so, may it please the court, and I'll say this. This is my reasoning for it. Of course, in that case, they said just because a man raised wheat in the field, he's just one man. He doesn't affect commerce by himself. But if you take all the rest of the farmers who raise wheat, they will materially affect commerce. I think that's in substance what they said. Well, the Reliance fuel oil case is an even more recent case, which says if a dealer does, if all the rest of the dealers does the same in this deal, therefore we've all in interstate commerce. If you apply that theory, may it please the court, let me show you how ridiculous I think that gets to be. Suppose the airport barbershop at Dulles International says we won't cut the hair of any man who's blind. And a man goes out there to get a haircut, and he's blonde-headed, he's from Scandinavia descent, and they won't cut it. Now, is that barbershop putting a burden on interstate commerce because he won't cut that man's hair? No. But if every barbershop in every airplane terminal in this country said they wouldn't, and you've got to presume that they would do just that, then all of them place a burden on interstate commerce. And therefore, if you carry it to the extreme, then Congress can cover every activity, every facet of life, because if you take any particular facet of life, even the manufacture of pencils that a lawyer has to use, and say that because every lawyer's got to use a pencil, if he doesn't do so-and-so, he's subject to that to the power of Congress under the Commerce Clause. It gets to a ridiculous situation where Congress then can do anything. And that gets me to another point that I want to make before I stop for rebuttal. This Constitution set up powers between the states and the federal government and enumerated them. And in the 10th Amendment, it reserved to the states all powers not set forth therein, to the states or the people. And the only reason for the existence of this Supreme Court, may it please the court, is to maintain the balance of powers between those different governments. And if this court will let Congress do anything it wants to under the Commerce Clause, and that's what that argument means. If this court will let them do anything, then this court has abdicated, and there's no reason for the existence of the Supreme Court to adjust and maintain the balance of powers between the various governments in this country. That is the function of the Supreme Court. That is the very reason for it set up in the Constitution, to balance those powers between the two by declaring the act of a state unconstitutional or declaring the act of Congress unconstitutional. And if you abdicate from that power, there will be no reason for the Supreme Court, because Congress then can do anything it wants in any facet of our life. I'll pose the question, which I'll try to answer in rebuttal. The real question in this case: how far can Congress go? What limit is it beyond which Congress cannot go? Is there any limit? Does Tennyson Brook run on forever too? What limit is it that Congress cannot overstep and pass?
You haven't discussed at all the thing that seems to me the most important on both sides. That is the series of cases, starting the germ of which started as Gibbons and argument, carried on in Mr. Chief Justice Hughes before he became Chief Justice in the Shreveport case, various other cases. Congress has not only the right to regulate interstate commerce itself, has the right to regulate local activities, wholly local within a state, purely intrastate, if Congress concludes, or if it is concluded that those would adversely affect interstate commerce, or that they would fail to give it the protection and fostering care which Congress is supposed to give it. It seems to me that you have not touched on that yet, and that for me is a very important part of this case.
And Mr. Justice Black, if you're interested in that, let me say something about it right now. We've cited three cases in this brief. One about the Yellow Cab Company in Chicago, one about Howard Johnson Restaurant on Interstate Highway, and about a bowling alley in New York State. And the Supreme Court has held that a man who went to Chicago to the railroad terminal and got off a train and got in a taxi cab, that taxicab was not involved in interstate commerce because the commerce that the man was in ceased and stopped at the terminal.
That's right. It was not engaged in interstate commerce. And for one reason or another, that case was decided as it was. But it does not have to be actually engaged in interstate commerce. Under the line of cases, actually beginning with Gibbons and Ogden, which have said Congress has a right to take care of interstate commerce, to foster it, to care for it, and to see that it is not adversely affected in any way, even going so far as to regulate the purely intrastate railroad rates in every state in the Union.
That's right.
And various other activities of that kind.
They've said they can come in.
The Sullivan case, which I happen to be familiar with, where the druggist they had received the drugs in his drugstore. All the connection that drugstore had with it was the drugs after they got them. But it was held that because those had moved in interstate commerce, under the line of decisions which I have just mentioned to you, that Congress had a right to regulate it.
I recognize, Your Honor, that...
Why wouldn't that apply here? That, to me, seems to me is your point.
I recognize, Your Honor, that there are a large line of cases that Congress can regulate under the Commerce power intrastate activities, purely local activities, if Congress thinks that they place that burden on interstate commerce. I'll try to hit that in the rebuttal.
But you will take that up later.
Mr. Solicitor General.
Mr. Chief Justice, may it please the Court. The fact that the Court is sitting to hear argument on the day that usually marked only an opening ceremonial occasion testifies more forcibly than any words of mine can do to the importance of the issues being presented today. The Civil Rights Act of 1964 is surely the most important legislation enacted in recent decades. It's one of the half-dozen most important laws, I think, enacted in the last century. No legislation within my memory has been debated as widely, as long, or as thoroughly. Certainly none has been considered more conscientiously. Perhaps there were differences of opinion that led to some confusion. Title II, as I shall show, is addressed to a commercial problem of grave national significance. I wish to emphasize, and will emphasize repeatedly in my argument, that Title II was addressed to a grave commercial problem, grave at the time the act was enacted, and plainly growing. Nor should we forget, Mr. Justice Goldberg, that Congress, in addressing itself to that commercial problem, was also keeping faith with the promise declared by the Continental Congress that all men are created equal. The failure to keep that promise lay heavy on the conscience of the entire nation, north as well as south, east as well as west. Nor do I overlook the difficulties of adjustment that accommodation to this act may require, difficulties that may bear heavier on some regions than upon others. Nor do I overlook the need for a spirit of cooperation and mutual understanding in facing those difficulties. We shall solve the problems as one people and thus escape the consequences of the sins of the past only if we act in the spirit of Lincoln's second inaugural, without malice, with charity, and perhaps above all, without that spirit of false self-righteousness that enables men who are not themselves without fault to point the finger at their fellows. Happily, the difficulty of the constitutional issues here is not equal to their importance. Title II, as we see it, rests upon the powers delegated to Congress by Article I, Section 8, Clause 13 of the Constitution, Clause 3 of the Constitution, to regulate commerce among the several states, and upon the power delegated by Clause 17 of the same article to enact laws that are necessary and proper to effectuate the commerce power. The constitutionality of Title II under those provisions is sustained by principles that are so familiar because they've been enacted over and over again, applied indeed throughout our entire history, going back, as Mr. Justice Black pointed out a moment ago, to the opinion of Chief Justice Marshall in Gibbons and Ogden. We do not seek the extension of any existing principles here. A fortiori, we invoke no new doctrine. I think it would be helpful if at the beginning
it is somewhat new, at least as I read the cases, to the extent that it involves a requirement that this motel serve a local person who hasn't moved in interstate commerce.
Well, even that, I think, in principle, Mr. Justice, I shall deal with this at more length in the course of my argument. I suggest even that in principle isn't new. The same point was involved in the Safety Appliance Acts requiring the equipment put on cars that weren't moving in interstate commerce, and in a case involving the inspection of cattle, which is also applicable to cattle which have never moved out of the state. But I do intend to deal with that point in a little more detail, if I may, later, after I've explained the general plan of the statute and the general principles which we think sustain that position. The particular application to this set of facts and to the practice of segregation is, of course, new. The Title II of the Act is printed in our brief in the Heart of Atlanta case, beginning at page 63, and I think it might be useful to go through the plan rather quickly in order to get oriented with respect to the particular provisions. Section 201, you will observe on page 63, declares the right of all persons to full and equal enjoyment of the goods, services, facilities, and so forth of any place of public accommodation as defined in this section, without discrimination by reason of race, color, religion, or national origin. The term place of public accommodation is then defined in subsection B. The character of places is listed, and those places are places of publication within the statute if one of two alternatives is satisfied. Either if its operations affect commerce, or if discrimination or segregation by it is supported by state action. Then subsections C and D define supported by state action and affect commerce. The definition of supported by state action is at the top of page 65. You'll note that it follows essentially the language of the Civil Rights Act of 1871. That section is not involved in either of these two cases. The government did not proceed in either case in the lower court and does not proceed here on the theory that this discrimination is supported by state action within the meaning of the statutory provision, which may or may not be as broad as the meaning of state action under the 14th Amendment. We simply make no argument on that point because we think this application of the statute is clearly brought within the commerce provision. Well, frankly, I find that alternative so unlikely that if we were to lose on that ground, I might despair of persuading the court on the other ground because I think that one is so much stronger.
There's nothing in this record about state action, is
there? It would seem to me that to reach that question here, one would have to conclude that this definition of state action reaches the operation of any restaurant or any hotel, any motel or hotel, without knowing anything about its relationship to the state. Now, conceivably that is true. That seems to me to go even farther than the argument presented in the sit-in cases, and we have thought it quite unnecessary in performing our duty to the court to discuss the issue. Theoretically, I think the court is free, Mr. Justice, to go ahead and consider that issue. If it should reach it, we would feel remiss in our duty as counselors not to have discussed it. But in our judgment, it's unnecessary to be considered.
How do you conceive the government basically reports the law? You can see Mr. Marshall's statement, which I will reference to Mr. Rollins, he statement that you conceive that there is no state action.
I think his statement was intended to be essentially the same as mine. To wit, the government was not relying on that point, that it made no concessions with respect to the meaning of 201D and no concessions with respect to the Constitution, but it hadn't offered any proof on the point and wasn't raising it. Certainly it would be proper for the court under those circumstances, I think, to say, well, the government can't stand on this theory. If it brings another case standing on the theory, we'll adjudicate it, but we're not going to permit them to raise that issue this late.
What do we do with the footnote of the brief?
Again, I think exactly the same as my statement, Mr. Justice, that we don't imply anything about the meaning of Section 201D.
Well, for the purpose of this case, therefore, you're really saying to us that we stand or fall on the right.
That's correct.
You said that specifically in your brief.
I hope the point's clear.
We stake our case, your language, we stake our case
on the Commerce Clause.
Civil Rights Act cases, civil rights cases aside, the meaning of state action aside, everything. You don't reach anything.
That's correct.
Correctly, that before you could really appeal to the state action provisions of the statute, outside now of the 14th Amendment itself, it'd have to be facts developed which brought you within the definition?
I would think so, unless one was prepared to say that the failure of a state to put a stop to something meant, in the language of 201D, that the segregation was carried on under color of any state law, statute, ordinance, or regulation. I would think that was an exceedingly difficult point to make. I don't want to concede it because the point may come up in the future, but I'm certainly not arguing it here.
Why do you feel more comfortable, I gather, arguing it if you had a record?
Much more.
All right.
Much more. And I would have three questions. I would first have the problem of some facts. We don't even know here that this hotel has a license, for example. Second, I would have to face the meaning of the statute, which is the same language as the Civil Rights Act, and therefore perhaps would be said to be enacted with a rubric upon it. And then finally one would come to Section 5 of the 14th Amendment. It seemed to me that there was no need, and it seemed to counsel in the court below, there was no need to traverse that path. That's true. Because the Birmingham statute, as a matter of interest, that was involved in the other cases, has now been repealed.
Exactly. So there, the fact is stipulated.
As you start your commerce argument, would you just take a minute to the apparent inconsistency between 201B and 201C1? 201B says that it is a place of public accommodation if its operations affect commerce. And in C, it says that if it's a motel, it does affect commerce. Are we dealing here with a conclusive presumption that a motel?
I think the case of a motel, there is in effect a congressional declaration that its operations affect commerce. If one further point is established, Mr. Justice Douglas, and in 201B, refers to any inn, hotel, motel, or other establishment which provides lodging to transient guests. And if the particular establishment provides lodging to transient guests and fits that general description, then it is deemed to affect commerce.
The fact, as I recall it in this case, that 75% of the transients are from out of state. In other words, would you be making this argument of 100% of the transients were residents of Georgia?
I would, provided it held itself out to accept transient guests indiscriminately. Obviously, I have here in this application a much easier case.
Necessarily interstate.
Oh, no, I realize that. It means that the hotel says we're willing to take anyone, and therefore it may tomorrow or the next day or any other day receive transient guests, or it may, even if it hasn't done it for many years, if the policy of discrimination is abolished, there then may be transient guests who apply to it.
Well, General, I don't suppose or maybe I'm wrong, that the definition of affecting commerce, namely transiency, is not exclusive as to what affects commerce. Well, the Congress did declare here that the motel affects commerce if it serves transient guests. Do you think that's the exclusive definition of affecting commerce? What if it doesn't serve transient guests?
If it doesn't serve transient guests, then I would think that...
You think Congress is also saying this is the only kind of a motel that will affect commerce?
No, I don't think it's saying that isn't the only kind of motel that will affect commerce within the meaning of the statute, within the meaning of the Constitution. I think that's the only kind of hotel or motel to which the statute applies.
You think the statute means to limit the applicability of the statute
well,
solely to transient motels?
I think I have to accept that as resulting from the statement in subdivision B.
Is there any motel that serves any except transients?
I wouldn't have thought so, Your Honor.
Otherwise, it's an apartment house,
But I think the reason for the other establishment affecting transient guests being put in is that to avoid the problem of what is a motel, what is an inn, and to reach other establishments. And then, again, I think, the fact that the particular establishment affects transient guests tends to link it more closely than it would otherwise be linked to commerce, and therefore to bring it farther within the ambit of federal regulation. Now, Mr. Justice White says, well, mightn't a hotel affect commerce in the constitutional sense, even if it didn't accept transient guests? Certainly. It might affect it through a number of courses of relationship. One would be that it received its food from out of state. Another sense in which it might affect commerce is that it might be a wholly impractical line for Congress to distinguish between those hotels that do receive interstate travelers and those that don't as of any particular time. And, of course, the Congress is free to consider the practical problems.
But I want to be clear, Mr. Sister, that the government's position is that it's irrelevant whether the transients, as long as they are transients, are interstate travelers.
That's correct. That's correct. They do, I point out, in this particular case. Now, if I might refer to the remaining provisions of Section 201C, in conjunction with Section 201B, you'll note that the second kind of establishment defined as a place of public accommodation is a restaurant, cafeteria, lunchroom, or other facility engaged principally in selling food for consumption on the premises and so forth. And C2 indicates that that kind of establishment is to be determined to affect commerce and therefore to be a place of public accommodation within the meaning of the prior subsections. If it serves or offers to serve interstate travelers, that's not involved in any of these cases, or a substantial portion of the food which it serves, or gasoline or other products which it sells, has moved in commerce. Subdivision 3 deals with various places of entertainment, movie theaters, other legitimate theaters, sports arenas, and the like. And they are deemed, according to C3, to affect commerce if they customarily present films, performances, athletic teams, and so forth, sources of entertainment that move in commerce. Then the fourth division, which scarcely concerns us here, relates to establishments which are functionally and physically interrelated with any of the foregoing.
Am I right in thinking that under this statute is drawn a department store? There's no restaurant in it, no sleeping accommodation is not affected by this act.
Provided it sells no gasoline.
Provided it sells no gasoline.
Yes, you are, Mr. Justice.
So that Saks Fifth Avenue, which deals in all kinds of interstate goods, assuming that it cut out its restaurant, if it chose not to serve Negroes, it wouldn't have to under this act.
Then this statute would not reach it. That's correct.
Why was that discussed?
There was, I don't recall very precisely. I think that one of the practical considerations that Congress undoubtedly would have taken into account would have been that the problem of discrimination is much less in the case of that kind of establishment.
That is no problem, based on the cases which have come here.
I didn't mean any constitutional problem.
No, what I'm saying, I'm simply suggesting that you're suggesting the right answer, that the department stores haven't factually presented a problem of discrimination or segregation anywhere. Isn't that correct?
Well, I wouldn't say quite anywhere.
Eating facilities and sleeping facilities that have.
Those have been, and entertainment facilities. Those have been the big problem. I wouldn't be prepared to say that there is no problem.
Cases come
has
here
been the other kind,
where the races have been welcomed equally to every place except the lunch counter. So.
And that is what if I can get onto it, was the problem that was emphasized before Congress, the commercial problems affecting all the states resulting from that kind of discrimination. That was the focal point, though not the exclusive point, in the enactment of this statute. I would like, and I think it'll be helpful in the long run, if I may continue the exposition of the provisions of the statute. I've noted already 201D. 201E simply provides an exemption for private clubs, and we need not concern ourselves with it. 202 is another substantive provision which applies even to retail stores, Mr. Justice Harlan, in the unlikely event that segregation or discrimination in a retail store is required by state law. I know of none, but that section I'm simply emphasizing is broader than the public accommodation section. 203 simply declares that no person shall violate the right to equal public accommodations, and that completes the substantive provisions of the statute. The procedural provisions become important in the next case, and I'd like to refer to them now. Section 204 authorizes a private suit for enforcement of the right to equal treatment in places of public accommodation, but there are a number of things that should be noted about it. In the first place, any such private action must be referred to a state agency, if there is a state agency empowered to prevent discrimination in such a place. And even if there is none, it may be stayed for reference to the Community Relations Service, an agency intended to, by persuasion, to induce voluntary compliance and the elimination of discrimination before it goes to judgment. Furthermore, and this is most important, you will note that the action that may be brought at the bottom of page 65 is a civil action for preventive relief. There is no right in any private person or anyone else to bring an action for damages, and a fortiori, there is no provision for criminal prosecution. This is emphasized when one comes to Section 206, which authorizes the suit by the Attorney General, which was instituted by a counterclaim in this Heart of Atlanta case. For he is authorized, when he finds a pattern or practice of resistance to the full enjoyment of any of the rights secured by this title, to bring a civil action requesting such preventive relief as he deems necessary. And the limitation of the statute to preventive relief is emphasized on Section 207A, over on 207B, over on page 69, which provides that the remedies provided in this title shall be the exclusive means of enforcing the rights based on this title. The only question on the merits in either of these cases is the constitutionality of the substantive provisions of Title II, particularly those impinging, first, on inns, hotels, motels, and like places offering accommodations to transient guests, and then second, those applicable to restaurants and other eating places which receive a substantial portion of the food served in interstate commerce. As I've said, we think that the constitutionality of both provisions rests squarely upon the commerce power aided by the necessary and proper clause. The major premise of our argument is the familiar rule that the powers delegated to Congress by the commerce and necessary and proper clauses authorize Congress to regulate local activities, at least activities that are local when separately considered, even though they are not themselves interstate commerce, if they have such a close and substantial relation to commerce that their regulation may be deemed appropriate or useful to foster or promote such commerce or to relieve it of burdens and obstructions. The minor premise of our argument is that Congress, to which the economic question thus raised is primarily committed, had ample basis upon which to find that racial discrimination in inns in the one case, inns and motels in the one case, restaurants in the other, does in fact constitute a source of burden or obstruction to interstate commerce. And of course, from those premises, the conclusion would follow that this is a legitimate exercise of power under the Commerce Clause.
You're not arguing, I take it, from what you just said, that Congress, by definition, can in effect preclude this court from taking a look at the record to see, the legislative record, to see whether in fact Congress had sufficient basis for the exercise of the commerce power that it purports.
I would put it in this. The direct answer is no. And I would state the principle. It's cited in my brief in a number of cases, and I shall refer to it a little bit later. But I would say that the principle is that if the person challenging the act of Congress can show that there is no rational basis for a practical, factual conclusion that this thing that it did, here the prohibition of racial discrimination or segregation in certain places linked to commerce, that it had no tendency, couldn't reasonably be found to have a tendency to foster or promote commerce or to relieve it of burdens or obstruction, then this court should invalidate. Now, I don't think that it is simply a matter of looking at the record before Congress. I'm quite content and do stand on the record made before Congress here, but I should point out that under many, many decisions, the question is simply whether the facts do exist, often or might exist, and the presumption is that they do, and there's no need for Congress or a state legislature to make any such record. Indeed, that's been held with respect to both in cases cited in my brief. But here the record was made, and we do cite it, and we think that we show that there was ample basis for concluding that this segregation in all these kinds of establishments was creating a grave national problem.
As a matter of fact, I presume most legislation in the country has been passed both state and national without findings by Congress.
Oh, yes.
And without hearings frequently.
That's true.
It's a question of whether they had the power under the Constitution to pass the law, not whether they made findings.
That's right. And the fact that findings are not necessary was held by this court in the Caroline Products case, and the fact that there need be no hearings, no legislative investigation, was held. I think the case is Grovey against Townsend, somebody against Townsend, coming from one of the southern states involving tobacco legislation.
Well, of course, it's also true, I think, Congress, when it's exercised its powers under the Commerce Clause, and particularly, you might call it extensions of preconceived notions of commerce power, has been at pains not only to make a substantial legislative record, evidentiary record, but to include in the statute elaborate legislative findings. And the bill that was proposed by the Justice Department, the immigration bill, proposed by Congress, proposed to Congress, did contain such findings. And apparently Congress, for some reason, best known to itself, choose to accept them.
But I don't think the change in the form of the bill, as I shall argue in more length in the second case, where this argument is interjected by the appellees. I was going to try to lay out the general foundation for what was done in this case and come to these specific objections later. But I think that it's quite clear that the record was made here, Mr. Justice Harlan. I think it's apparent from the statute, as I will argue, that there was no shift in the congressional analysis. I would also say that although the practice in recent years has been to make both the record and has often been to make the findings, that the practice, as Chief Justice Stone pointed out, the United States against Darby, has often been the other way, probably more often than it has been this way. And certainly this court has made it plain over and over again that the findings are not required. The findings make it a lot easier for the Solicitor General, I agree.
All right, but this idea of making findings, whether state or federal, largely started sometime in the 30s, didn't it?
During the 1930s, the precedent, I think, went back to early Elizabethan recitals of whereases. In the intervening period, it wasn't done. And, of course, as Justice Black said, it is almost never done. I think one could almost say without fear of contradiction, is never done. It's state legislation. It was a short term.
They don't even take recorded hearings in it.
No, no. Well, I really don't think I need consider any such point, Mr. Justice. It may be. The difficulty is that we all know that one of the basic, unspoken predicates of the agreement on the Constitution involved some acceptance that the national government had no concern with slavery. And I hesitate to agree with you for two reasons. One is that it seemed to me there might be some room for argument on that. The second one is I think it is very dangerous to say that anything Congress can do under the Commerce Clause today, that is a regulation of any specific person or local activity, that it may reach today, it could have reached in 1789, and conversely, that anything it couldn't reach in 1789, it can't reach today, because while the principles are constant, while what we are concerned with today is the free flow of goods, as counsel suggested, quoting from the Federalist, and what we're concerned with is the application of the principle laid down by Chief Justice Marshall just a few years later. Still, the facts change. things affect interstate commerce today that may not have affected it earlier. Therefore, I prefer to confine myself to what affects commerce now. As to the other, it may or may not be true. I do think that the principles are constant, that we invoke no new principle.
That they comply with that part of Marshall's statement, that the end be legitimate, and so forth. The end is legitimate.
That if the end is legitimate and the means are reasonably adapted to fulfilling. It cannot be
said that it's illegitimate end to try to carry out a policy which the Constitution commands.
Nor can it be said here that the prohibition of segregation in these establishments is not a means reasonably adapted to freeing interstate commerce from obstructions and burdens, the permissible objective that Your Honor refers to. After the recess, I'll turn directly to the factual evidence bearing upon the appropriateness of the means to the end. Thank you, Mr. Chief Justice. I see no reason, if I understand Your Honor's question, to suppose that the 14th Amendment and Section 5 thereof were intended to curtail the power that Congress would have under Section 3, the appropriate clauses, to deal with things that were obstructions to interstate commerce. No, it would deal with the things that were obstructions to interstate commerce under the Commerce Clause. Yes, and I'm not sure that I understood Your Honor's question. Maybe if I could restate what I. Yes. Yeah, well, my answer would be no, that the fact that the power that Congress was given in the 14th Amendment was limited to the implementation, the enforcement of the requirements of that amendment does not seem to me to imply that the power that was given in other parts of the Constitution earlier to deal with obstructions to commerce, whether local or in commerce, had been curtailed. I see no reason in interpreting the 14th Amendment to suppose that the rule expressio unias exclusio alterius applies. It would seem to me that, indeed, I wonder, Mr. Justice, whether that isn't, well, perhaps not. Isn't the argument very similar to that? Well, part of my answer must be to repeat what I said a moment ago, that it doesn't seem to me that one should draw from the conclusion that Congress was given an additional power, an intent to curtail its power to enact legislation, which appears, in fact, reading the legislation, to be reasonably adapted to dealing with a commercial problem. Now, so far as what was the dominant motivation here goes, or what was the constitutional theory on which the Congress or different congressmen acted goes, I suggest that is irrelevant. My own inference, knowing something about the legislative history, would be that Congress accepted the advice that it was not, while each congressman must satisfy himself that he was doing his duty of conforming to the Constitution, that there was no occasion for Congress to commit itself to any particular theory. That so far as that had to be decided, that was something for the government to do or anyone else to do, including the courts, in determining the constitutionality of the legislation. I think that's the fact. I don't pitch my case upon it because I don't think that it's a proper inquiry for the court to do more than look at the legislation, to inquire whether this is a useful, appropriate, necessary in that sense of necessary, way of dealing with a commercial problem. If it is...
What was the dominant purpose of the Mann Act and the law that stolen vehicle?
Well, I would think they had to do with morals rather than commerce. I think, again, that... But I think, Mr. Justice, this is a doctrine that has been applied over and over again. It was applied in the McCrae case to the oleomargarine tax. I think it was applied so there was no discussion in the Labor Board cases.
Well, Mr. Solicitor, you suggested anyway that perhaps that's not subject to legitimate inquiry for us, but what does this record show? Is it necessarily that it was racial discrimination in this context that was the basic objective of the legislation? Or is it also susceptible, as I thought you suggested earlier, that there are obstructions to commerce and serious obstructions to the free flow of commerce, which they may have a racial basis, but that is the evil at which the legislation is aimed?
Well, I think the record must be admitted to show a very great concern with the problem of the effect of discrimination on commerce, a great concern with the fact that it was a national commercial problem. And when you turn to the evidence that was before Congress, you find that there was overwhelming evidence to that effect.
I thought the question was whether the activity had a sufficiently close and substantial relation to interstate commerce, as far as we're concerned.
Quite. And
we're not concerned with the policy of Congress as to segregation, integration.
And, of course, when Congress was addressing itself to the national commercial problem, it had to take into account other aspects of this. If there are alternative approaches to the problem, then it had to choose between them. And I suppose that there, in theory at least, were alternative approaches to the problem. A rigorous enough suppression might have ended the obstruction to interstate commerce, but clearly Congress is not required to choose any particular alternative, provided it does not offend a specific inhibition of the Constitution. Now here, this was, I'd like to emphasize and go into it in a little detail, a very real national commercial problem. And the record shows that beyond a peradventure of a doubt. Let me talk about it first in somewhat general terms, and then turn specifically to the motels and hotels that are involved here, and thereafter specifically, since we're looking at the Act in general, and the general plan of the Act, to the effect upon restaurants and the like. I simply say parenthetically first that, of course, this general principle that Mr. Justice Clark referred to a moment ago has been applied to the activities of hotels and motels and restaurants under numerous statutes, the Sherman Act, the laws administered by the Federal Trade Commission, and the National Labor Relations Act. Now, Congress started with the outstanding fact, I think, of national life during the past decade, perhaps longer, the thrust toward the realization for Negroes and in some instances other minorities of the promise that all men are created equal. We're concerned here with the commercial consequences, which were of nationwide scope and almost incredible proportions. Not unnaturally, much of that pressure that I refer to was centered on racial discrimination in places of public accommodation, a practice that was not confined to any one section of the country or to any particular type of establishment. Congress heard evidence, for example, in about 2 months in the spring and early summer of 1963, that there were 634 demonstrations in 174 cities and 32 states and the District of Columbia. About a third of those were concerned solely with discrimination in places of public accommodation. Others had a broader scope. The effect of those demonstrations, picketing, boycotts, other forms of protest, upon business conditions and therefore upon interstate commerce was dramatic. The Undersecretary of Commerce described the business consequences in considerable detail, but for illustrative purposes, it's enough for me to take what happened in Birmingham in the spring of 1963. In a 4-week period extending from the middle of April to the middle of May, department store sales, as reported to the Federal Reserve Board, were 15% below the level in 1952, although in comparable cities they were rising. Businessmen stated that the number of business failures during that period was greater than in the Great Depression of the 1930s. Downtown stores reported that their April sales were off from 40 to 50% during the period of these demonstrations. And the Undersecretary described in his testimony similar experiences at other times in Savannah, Atlanta, Charlotte, North Carolina, and Nashville, Tennessee. Now, it's evident that any general downturn in business, in retail business, will, if left unchecked, result in serious disruption of the flow of goods across state lines. If the retailers don't sell, they won't buy. And if they won't buy, the demand for goods flowing in from other states, of course, will be checked. The flow of goods will be dammed up. A top retail executive epitomized the commercial aspects of these demonstrations very effectively. He said, "This thing has frightening ramifications. It's now become an economic situation affecting the entire community, the whole city, and the whole country." I emphasize that he said it was an economic situation affecting the whole country. No less important is the impact of racial discrimination, disputes, and other forms of civil unrest upon the flow of investment and the location of enterprises. The Secretary of Labor, who had had a study made before testifying before Congress, summarized the results of the studies made by his department. Industry, he said, is discouraged from locating or expanding in communities where equal opportunity does not exist and incidents have taken place or likely to occur. Lack of equal facilities for employees and even the latent possibility of demonstrations often removes the locality from consideration as a site for commercial or industrial expansion. This affects industrial development regionally and nationally by limiting the flexibility and free choice of business and hampering labor mobility. The evidence before the congressional committees was replete with specific examples of that general statement by the Secretary of Labor. The most dramatic was the experience in Little Rock, Arkansas. In the 2 years before the racial crisis in that city, Little Rock had gained 10 new plants worth almost $3.5 million and creating 1,000 new jobs. In the next 2 years, a comparable period, there was no new industry located there employing more than 15 employees. Even industrial development in the whole state of Arkansas seems to have been affected. In the previous 2 years, they gained businesses worth $248 million. In the next 2 years, the volume was cut to $190 million. Now, I have no argument in this case to argue that the general impact upon interstate commerce of such widespread disputes growing out of racial segregation is alone sufficient to support Title II, because Title II does, as I pointed out earlier in my argument, also require, with respect to each of the kinds of business regulated, some nexus between that establishment and interstate commerce. What I do say with respect to this general evidence is two things. First, that it shows that the general impact of these disturbances arising out of racial discrimination was not merely social and moral, so nobody denies that aspect of it, but that it was national and commercial. And second, that the importance of the relationship between any individual establishment and interstate commerce, as made out in accordance with Section 201C, is to be judged in the light of the fact that its practices and any incidents that might occur there would be part of a complex and interrelated problem affecting interstate commerce when they were added together all over the country. I come now, if I may, to the specific problem of the relationship between discrimination in hotels and motels and interstate commerce. You'll recall that Section 201B and C provide that any hotel or motel or like establishment that accepts transient guests shall be deemed to affect interstate commerce and through that provision to be a place of public accommodation. The appellant plainly falls in that category. It's not only conceitedly a motel, but 75% of its guests come from out of state, and it advertises out of state. The testimony before Congress provided literally overwhelming evidence that discrimination by hotels and motels impedes interstate travel. And I suggest that there is no possible doubt since the Edwards case or before the Edwards case that interstate travel by men and women is interstate commerce. We've summarized the testimony in our brief, and I refer to it very shortly here. Again, the Undersecretary of Commerce dealt chiefly with the point. He concluded, after study by the Department of Commerce, not only that interstate travel was made incredibly more difficult for Negroes by reason of discrimination in hotels or motels, but that its volume as a whole was sharply curtailed by the unavailability of adequate public accommodation. The administrator of the Federal Aviation Agency testified to the same effect. The witnesses, these witnesses and others, described the problem in some detail, and you have the references from our brief. Suffice it to say, because I think it epitomizes the point, that on a motor trip between Washington, D.C. and Miami, Florida, the average distance, it was found, between accommodations of reasonable quality open to Negroes was 141 miles. And when we think of the frequency by which we go by other hotels and motels open to everyone, the significance of a 3 or 4 hour drive between the hope of accommodation is very significant indeed. And it further appeared that those accommodations that were available to Negroes were on the whole likely to be small, so that after driving 3 or 4 hours, one might well find no vacancy sign and have another equally lengthy drive ahead of it. I use this only as an illustration, I want to emphasize. Similar problems, according to the testimony, exist in other parts of the country. Segregation in hotels and motels has an even more dramatic effect upon the sites chosen for conventions, which of course account for a large volume of interstate travel. Dallas, Texas, for example, found that it benefited very much from the voluntary opening of its hotels to conventions where there was no segregation. The Atlanta Convention Bureau, within one day after 14 Atlanta hotels desegregated, received commitments, not feelers, but commitments, from organizations expecting over 3,000 delegates, which would not have gone to Atlanta if segregation were continued to be practiced. Again, New Orleans found an American Legion convention expecting 50,000 people transferred to another city because New Orleans could not guarantee equal public accommodations. Plainly, this kind of restraint has a most marked effect upon the volume of interstate travel. It won't do to say, well, people will go somewhere else. In the first place, it seems to me that that's unlikely. But in the second place, of course, any practice that distorts the flow of commerce, that prevents it from flowing freely, if Congress thinks it desirable to flow freely, is itself a restraint on interstate commerce, and something within the power of Congress to deal under the proposition that I stated earlier.
You say people are commerce.
I say that the movement of people from state to state is movement in commerce, yes. I hesitate a little to say that the people are commerce, but it's certainly movement in commerce.
Certainly that's what Edwards against California.
Squarely holds. Squarely holds. City of New York against Milne, as shown in one of our two briefs, was overruled in either the passenger tax cases or the head money cases. I forget which one. It's pointed out in the footnote in our brief.
I thought Edwards.
Yes. Well, then you may be in a somewhat special category.
I thought Edwards distinguished Milne. Is that right?
Well, I understand that it was overruled earlier. The reference is in our brief. I think Edwards is the first case that can be said squarely to have embraced the proposition that the movement of people across state lines is interstate commerce.
Of course, those were certain types of people. They were Okies and Indians. That's what the statute was aimed at.
Yes, but I take it that if Okies are commerce, so are other people traveling across state lines. I had intended to indicate the factual evidence relating to restaurants, but in view of the passage of time, perhaps I had better save that for the next case and move on here. Simply to summarize on the factual point, we think there was ample evidence on which Congress could conclude that the racial practices in hotels and motels and like places did have a very substantial effect upon the movement of people in interstate commerce, and that therefore this statute, as applied to them, is a measure adapted to freeing interstate commerce from restraints and burdens. Now, of course, once that conclusion is reached, the size of the establishment is obviously irrelevant. The Reliance Fuel case determined that. The fact that Congress has prohibited hotels and motels from discriminating against all guests rather than against interstate guests does not invalidate the statute. To require a traveler to carry a cachet to show that he's interstate would itself be a burden on commerce. Furthermore, to require the Negro interstate traveler to prove that he was traveling in interstate commerce would itself be a form of discrimination, well nigh as invidious as the former practice. Because this establishment... That's true. That's true. And I think that... Yes, yes. That's true. But I would make the same argument under the Commerce Clause. I do want to emphasize that without going over to the 14th Amendment. Yes. This one does, but the statute draws no distinction, and I think there is no constitutional distinction.
I think the second case does not solicit any state.
That's true. The second case, of course, relies on a ground of coverage not present in this case, or at least not shown to be present. And that is, we rely on the fact that this is an establishment which receives indirectly shipments of food in interstate commerce. I wonder, Mr. Chief Justice, if I might borrow a few minutes from my time in the other case. I will deal in the McClung case, the next case, with the special arguments made there under the Commerce Clause. But since they aren't raised here, I thought it better to postpone them. Now I come to the other constitutional objections. Once it is established that the enactment of Title II is valid under the Commerce Clause, then, of course, the arguments based on the 9th and 10th Amendments disappear, because it has been law since Martin and Hunter's lessee and McCulloch in Maryland that if legislation may be sustained under one of the granted powers, then the 9th and 10th Amendments do not cut off what would otherwise be the power of Congress. And that proposition was re-enunciated in the Darby Lumber case for a unanimous court by Mr. Chief Justice Stone. The argument that Congress violated the Fifth Amendment has equally little merit. Certainly there's no taking of property for a public use. The regulation of the conduct of a business is not a taking. Appellants say that they will lose profits as a result of this regulation. Experience rather indicates the contrary, but assuming that that is true, still it has clearly been held that subjecting a man to regulation otherwise proper, along with all other similar businesses, does not violate the Fifth Amendment simply because he loses money. Nor does the prohibition of racial discrimination take liberty or property without due process of law. Over and over again, the court has sustained and enforced statutes prohibiting various forms of racial discrimination. The Boblow excursion case dealing with the excursion boat on the Great Lakes, the case here involving Continental Airlines and discrimination in employment a few years ago, the Thompson case dealing with restaurants in the District of Columbia, the Boynton case dealing with restaurants that were part of the transportation service of a bus line, and I could go on and add numerous others. Appellant also argues that the Act violates the 13th Amendment. It's enough to point out that the appellant is a corporation, but surely it would turn the world quite upside down for anyone to seriously suggest that the 13th Amendment was intended to prohibit either Congress or the state governments from guaranteeing Negroes equality of treatment in places of public accommodation. And Alice, I think, even at the end of her long journey through the Looking Glass, would have been surprised to be told that the restaurants and other places of public accommodation in 33 states in the year 1964 are held in involuntary servitude, and that the Anglo-American common law for centuries has subjected to slavery innkeepers, hackmen, carriers, wharfingers, farriers, all kinds of other people holding themselves out to serve the public. Nor will it do to say that, well, those are businesses affected with the public interest. because the 13th Amendment abolishes slavery in businesses affected with the public interest just as much as anywhere else. Of course, the real answer is that this appellant, even if it were a person, could stop holding himself out as a motel willing to do business with the public. And as long as one is free to stop, then there is no forced labor and no violation of the 13th Amendment. Now, the remaining point concerns the civil rights cases of 1882. If, as I have argued, this legislation, as applied in this case, is valid under the Commerce Clause, then the standing of that decision is not drawn in question. The court made it clear that the Act of 1875 was drawn in another view. And I take it the respect in which it was drawn in another view was that it covered a great many enterprises, theaters, local public conveyances, which on any facts before the court or any facts known to Congress probably did not then affect interstate commerce. In other words, the statute was framed in another view in the sense that it was much broader. I would suppose, Mr. Justice, that a theater, which in 1880 had employed only local actors, which had only local scenery, which had only local stage hands, if you will, and orchestras, would not. It certainly wouldn't have affected interstate commerce within the meaning of this statute, and I think it would have been a question of whether it affected interstate commerce in any sense. Now, I expect that there were a great many establishments of that kind in that day. And, of course, if such an establishment exists today, the Act doesn't reach it. What I'm saying is that that statute covered a great many things that were not shown anywhere to affect commerce, and that the court therefore had to consider perhaps two questions. One, whether the statute was valid in the broader applications, which was presented in the 1882 cases. And then later it had to consider, which was presented in the Butts case, in a sense the question of separability, whether Congress would have wished it to be applied to those places which Congress constitutionally could reach. And the court held that it was not separable, that it had not been addressed to the commercial problem. Yes, sir. The situation. Well, there's a curious little quirk about that. The facts appear to be these. The civil rights cases, of course, involved a number of cases. Two or three of them got to the court several terms back in 1878 term or 1879 term. At that time, a brief was filed by Attorney General Devens and an Assistant Attorney General. And there is in one passage of that, of course they were very short briefs as they were in those days, there is one passage there that alludes to the fact that the Act is being applied to a railroad, which would, of course, he said in effect, be subject to regulation under the Commerce Clause. Then he went on and argued the whole case under the 13th and 14th Amendments. Then that brief was apparently forgotten, as I suppose our briefs sometimes are. And when the case came on for argument 4 years later, I think, Solicitor General Phillips filed another brief, and that's the one that most people look at. And that brief makes no reference to commerce whatsoever. Then, of course, the court, close to the conclusion of the opinion, I won't stop to read it, but you'll find very close to the conclusion of the majority opinion, a statement that no argument under the Commerce Clause is pressed upon it. And I suggest that I gave at least one of the reasons earlier. Now, I don't mean to be disingenuous. There may be different views about the Commerce Clause today than there were then, but I do submit most seriously that many of these differences are differences in the factual conditions that exist today, and not any difference in the principle. That's why I suggest very sincerely that the print case here falls within the principle laid down by Chief Justice Marshall in Gibbons and Ogden, and that is virtually as old as the Constitution itself.
Thank you, Mr. Chief Justice. Mr. Chief Justice, and may it please the court, the argument of counsel today is quite different from the argument the Solicitor General made in the case of Bell versus Howell. I'd like to read one statement that's reported in your opinion that the Solicitor General made. The preservation of a free and pluralistic society would seem to require substantial freedom for private choice in social, business, and professional associations. Freedom of choice means the liberty to be wrong as well as right, to be mean as well as noble, to be vicious as well as kind. And even if that view were questioned, the philosophy of federalism leaves an area for the choice to the states and their people when the state is not otherwise involved, instead of vesting the only power of executive decision in the federal courts. How does he square that with the argument today?
What word in the federal court? He didn't say in federal Congress.
But his argument today, may it please the court, is that the Congress had the right to pass this act about all motels because motels deal in people, and people get to the motel by interstate commerce. And therefore, all people that come into that motel are in interstate commerce and be covered. He further says that the real reason that Congress has the right to, therefore, pass legislation that affects all motels and all people is because of the conditions that have arisen in this country that places burdens on interstate commerce. Now, remember, the brief filed in this case by the government talks about the burdens that existed in 1963, but his brief also shows in Atlanta, Georgia, that there were 14 of the major hotels that had already desegregated. As a matter of fact, it shows how much business he says we've gotten in Atlanta because they had. And the truth of the matter is the Heart of Atlanta Motel is the only place in Atlanta, Georgia that hasn't desegregated voluntarily. Now let's turn the coin the other way. Suppose the Heart of Atlanta is the only place in Atlanta that doesn't desegregate voluntarily. Does that one motel affect commerce so badly and place such a burden on it that Congress can pass the law? If that one motel out of 60,000 in the United States is the only one that doesn't desegregate, does that place a burden on Congress, on interstate commerce? And if the purpose of the passing of the Civil Rights Act was to relieve the burden on interstate commerce, by virtue of reference to the things that happened in Birmingham and Little Rock and so forth, all of which happened some time ago now, thank goodness. If it was to relieve the burden on interstate commerce, has it done so? All the desegregation, mostly in the most cities in the South, has occurred before the passage of the Civil Rights Act. There's no mention in the brief or an argument of the things that have happened since the passage of the Civil Rights Act. There's no mention of riots in the streets in New York or Rochester or Philadelphia. Has the act accomplished anything? This court is not here to determine whether Congress acted wisely or not. It is only here to determine whether it acted legally within the Constitution. Counsel has said that there's only question, is there a rational basis for the legislative determination based on the burden placed on interstate commerce? We get to the question that Mr. Justice Black posed in the morning, and Mr. Justice Goldberg posed. And I have to come to grips with it to answer. And the question is, Can Congress control racial discrimination by an individual where there is no state connection at all, and there is none in this case? There are no laws on the books of the state of Georgia or in the city of Atlanta, with two exceptions. One of them is the anti-trespass law, which does not mention race as a grounds. It can be used to keep anybody in this courtroom out of a man's place of business if he wants to. And the other one is, as far as I know, they're all about the marriage of races. But if the Congress can pass the law to cover all commerce and include all motels, we have to face the issue of whether or not one individual is the gauge, or whether one individual business can, with all other businesses in that field, such as Reliance fuel oil cases, will affect all commerce. And whether or not the phrase used by our counsel frequently in his argument about commercial activities is sufficient to give Congress the power to pass regulations and a code of laws that affect personal conduct of individuals. Your Honor, I intend to answer it absolutely truthful as I should. In my opinion, the argument of counsel and of the government that this is done to relieve a burden on interstate commerce is so much hogwash that the purpose of Congress was to pass a law which some way or other they could control discrimination by individuals in the whole United States. I agree that is the reason they passed the act. But the Yes, Your Honor. And I started off my argument, yes, Your Honor, that I did not want to go into the reasons why Congress passed the act or whether they're right or wrong, because this is a court of law. And we're not arguing a case for a jury on facts, as the last half of the argument of the government has been, as to whether the facts justify the means adopted by Congress. This is a court of law to decide whether Congress had the right under the Constitution, the legal right, not whether it was a good thing to do or whether it's a human thing to do or the kind thing or the moral thing. That's where I was trying to come to grips with your question and Mr. Justice Black's question, because I think this is the answer, and I'll now propose it. The government just quoted the schoolboy familiar quote that all of us know, but none of us much understand, I think, that all men are created equal. It's in the Declaration of Independence. I don't believe it's in the Constitution. But Chief Justice Duckworth of our Georgia Supreme Court has said in one sentence something as clear to me than anything I've ever heard on the subject of all men being created equal. Liberty stops where to extend it invades the liberty of another. I didn't come here to talk about commerce. I didn't come here to argue the question of whether or not this motel has an effect on commerce. Certainly everything that happens in this country has an effect on commerce. But I did perceive, I hope, that in the writings of members of this court, there is still the great facet of personal liberty that this court stands for. This court, under the Constitution, is the last bulwark of personal liberty. Where else can a man go to defend personal liberty? So if you get to your questions that you ask, the answer is that commerce has got to stop somewhere with commerce, in the sense that a business function is commerce, and that the power of the Commerce Clause under the Constitution does not go to people. If you don't accept that fundamental, I'm lost. But Mr. Justice Douglas wrote an opinion just recently in a case argued from Atlanta by a friend of mine, in which Mr. Justice Douglas eloquently spoke of the freedom of association in the union shop case. Since neither Congress nor the state legislature can abridge these rights, they cannot grant the power to private groups to abridge them. As I read the First Amendment, it forbids any abridgment by the government, whether directly or indirectly. There are opinions of this court that talk about the freedom of the individual in the Bell case to discriminate if he says that's what he wants to do, regardless of what Congress says. In the Bell case, provided there's no state action. No, whether or not there's a state statute or not, or any state action, not come. In the union shop case, they spoke of the freedom of association guaranteed by the First Amendment. The Sixth Amendment says, the Sixth Article of the Constitution says that only laws passed pursuant to the Constitution are valid, and that this court should, in their interpretation, determine whether they are or not. So unless this court says that commerce stops with personal liberty, then there's no end to it. Yes.
Traveling along the highway have no place to stop, no place to spend the night. What is your argument to say that wouldn't likely create a burden on commerce?
Well, I'll have to go outside the record to answer that, I think.
Well, I'd like to have it answered outside
Yes.
or in the record, because as far as I'm concerned, that is the crucial issue here as to whether we can say that Congress was wrong in thinking of depriving a large segment of people of the right to stop anywhere at night when they're traveling in interstate commerce. Whether they had a right rationally to say that would put a burden on commerce that Congress ought to lift.
Mr. Justice Black, I wish I'd had the opportunity to appear for the committee that took the testimony on whether that was a factual situation or not.
Well,
I've
read the facts in your case.
Yes.
You have a motel right along the highway that I'm reasonably familiar with. People go up and down all over the country traveling down that highway. Your motel is there. I understand your position. You believe that it's into your business, as frequently always do. But you have a highway there, and 75% of the people who come there come from outside the state, one way or the other. And you have advertisements asking them to come. So your problem in this case, as I see it, under our former opinion, going back to the very beginning of the century, the 19th century, whether or not Congress, we've got a right to say that Congress is wholly irrational in saying that if these people are deprived of the right to spend the night on that trip, that would likely create a burden on Congress.
Mr. Black, Justice Black, let me say why I said I'd like to have testified. Because I probably know more about personally the travel of the Negro race than any white man in this room. For the simple reason, for 10 years, I've been president of a corporation that owns and operates a Negro motel in Atlanta. And I know for a fact, from the operating of this motel, which is widely known, been in every national magazine and publication of wide distribution in the Negro press, a widely known small motel, very nicely appointed and very adequately run. And I'll tell you that there are not enough customers to fill that motel up every day of the week, and there are not but 20 rooms in it.
That's in Atlanta.
That's in Atlanta.
Have you traveled with any colored people from the southern part of this country back up to Washington?
No, I haven't, but my manager of the motel who runs it is the chairman of the board of the Nationwide Hotel Association, and he knows almost firsthand the owners and operators of some 60 Negro motels up and down the east coast of this country. But in addition to that, most chains, Holiday Inn has 500 units. They've all desegregated before the Act. Howard Johnson has about 400, and they've all desegregated before the Act. Quality Court has 600, and in half the states they operate under a state law which requires them to desegregate, and the rest of them have. You take most of the major chains of motels in the United States, and I know for a fact now, have already desegregated and were before the passage of the 1964 Act. And as a matter of fact,
Why wasn't it segregated? Do you have any idea?
in all instances, I think, as a matter of policy, because most of them were national in scope.
And it had something to do with the profitability of the commercial operation?
Well, I'm sure it did. 30 states, of course, have laws that cover this subject. And they, of course, had to apply with those laws. And where they had chains that operated in states that did not have a public accommodation law, state law, they, as a matter of public policy, had changed and moved with the times, if you want to call it. So, as a matter of fact, when Congress passed the Act, there was not any shortage of rooms in the United States for colored people to use. They may have been in Atlanta when the heart of Atlanta wouldn't, but we're doing it on principle. We started this case 2 hours after the law was passed on principle because we didn't think Congress had the right to do what they did.
Well,
but as a matter of fact, the Congress did not have any elders before them that would say at that time in 1964, maybe in 63, when all the evidence is before the court, really, it's in the record.
But if
was
there
given.
weren't adequate accommodations, as you say there are and were, if there weren't those adequate accommodations, the question would be different?
That's true. In 1963, the Act might have had some basis for saying that it was a burden on interstate commerce.
So in 1960, this law would have been all
I didn't finish, may it please court. But the fact that they tried to place people under commerce and call them a subject of commerce applied in 63 as well as now. I'm just meeting his argument on facts if I could. As a matter of fact, we're talking about facts that anybody could say is a fact, but it may not have been a fact. The people who testified for the committees, who were they? One man named Roosevelt who glories in the name of a great father and done nothing much else, especially in this field, and a man named Roy Wilkins who is employed by an association to have that view. Was there any mention in any of the documents before this court about the findings of Senator Russell or what he thought about it? He was on the committee. I think all the states would have the right to pass a public accommodation law except for one thing, and I've said so in the brief. I think they, in substance, they themselves violate the 13th Amendment. And except for that, I think the state has a right to pass a public accommodations law. Because that is the state exercising police power in the state, which the federal government ought not to exercise. I think the 13th Amendment avoids all of it. Well, that's just stated simply as fast as I could.
Going back to your occupancy statement, what's been the experience of the Heart of Atlanta since the injunction was granted as to occupancy?
That's a good question, Mr. Justice. The injunction went into effect on August 11th. Just to show you what a great market there is for Negro guests traveling in interstate commerce. We've had 3 requests in 2 months. At one time, we were full and had no rooms. The other 2 times, we took them. We've had 3 requests, and Lord knows this case has been in the papers, and every member of the Negro race in the United States knew that we wanted an injunction to take them. Right in the middle of the summer, in August, which is the biggest travel month called the American Automobile Association, we had 3 guests. not of those three guests, but it refutes the argument that there's a burden on interstate commerce because there's no place for them to stay.
What effect will it have on you then if they don't have any requests?
Very simple, Your Honor. We ran I'm glad you asked, because I couldn't go into it otherwise, I don't think. We ran a survey with 5,000 guests to the motel. Sent out 5,000 to our repeat customers who've been there 2 times or more, and asked them this question. If a member of the Negro race was using our recreation facilities, which consist of 2 pools and an area 200 by 100, and other things in that recreation area, would you use the swimming pool, and would you use the recreation area? And 90% of those people said they would not.
That's not my question. My question was, since you only had 2 actual occupants since August the 1st, you wouldn't have any in the swimming pool very often. So that's not the question. Is what effect it would have since there's such a paucity of applicants.
It hasn't had any effect, really.
Not at all.
But the question is whether or not these people would come later as far as an economic effect. But whether it affects us badly or not is not the question of whether or not Congress had the right to pass the act to begin with. If it helped us. Council seems to think that the act was passed for the benefit of the people in Birmingham and Little Rock and other people who'd had racial disturbances in the South. There are 43 million white people in the South. And I'll say for all of them, so loud that Congress can hear, please don't do us any more favors if it's for us.
Well,
like a man said, with friends like these, who needs enemies? Our point is that it's whether or not they have the right to do it, not whether they could. Congress can do anything if this court does not stop them. But whether they have the right to do what they do is the question.
You agree that they have the right to do it. If Congress had a right to reach the conclusion that it would be an injury to interstate commerce for them to continue to refuse to accept people on account of government.
Mr. Justice Black, I don't go quite that far. I say that Congress has a right to remove burdens from interstate commerce if it pertains to commerce. But I believe that the rights of individuals, the rights of people, the personal liberty of a person to do what he wants to run his business is more important and more paramount than the commerce of the United States.
Now, I'm supposed to say it has the right to do it if it pertains to commerce. If it does pertain to commerce, and would create a burden for the discrimination to be practiced, is Congress denied its power to protect commerce because of the fact that it relates to discrimination?
Yes, sir, because there's a paramount duty on Congress to protect individual liberty over and above trade. And that I said is the crux of the case. This court, it seems to me, has got to decide whether or not commerce includes individuals. It's that simple. If it does, then the act is constitutional. If they don't have the right to fetter and take over a man's liberty to run his business, then this act is unconstitutional.
Do you think of any law regulating commerce that doesn't affect individuals?
No, but this is different. This is different in that it makes people do something.
Based it on the idea that they can't do it if it affects individual liberty. Every regulation of a railroad, every regulation of a public utility, every other commercial regulation affects the liberty of some. So Congress reaches the conclusion that for the best advantage of all will it be done.
But every railroad and every public utility is operating on a franchise because they have a monopoly, or virtual monopoly. And the Congress is entitled to place restrictions on them that they would not ordinarily place on every human being in the United States.
Well, that's not true with reference to the wage and hour law.
Well, they still put it on the basis of volume. They put it on size. They don't say every business in the United States is under the wage and hour law. You got to have a volume of 500,000 or more in business.
Well, that's not what Congress did. It was first done by the board, but that's immaterial. What you have is you are asking, in effect, that the Hammer and Dagenhart be put back in the rule. The argument in the reason Hammer and Dagenhart was overruled, the argument was made there, like you're making here, that while they can regulate Congress for some purpose, you can't regulate it to protect child labor or women from labor. And the court held that. Later on, that was overruled.
This means putting back in the Constitution that the liberty of an individual is more important to interstate commerce than that's what I'm asking. That's right. my light is on, I'd like to say this much more. The poet Shakespeare once said, and it's my favorite quotation, that there is a tide in the affairs of men which, taking the flood, leads on to victory. I say to you that this is the full flood tide in this country at this time. From this point on in history, because of the issue I'm raising about people, the people of this country will know whether the government exists for the purpose of the preservation of the liberty of people or exists for the purpose of allowing Congress to concentrate power in Congress and in the national government. And it's as simple as that. Under the Constitution, the decision is yours. You're not responsible for the consequences of the decision, but I submit you are responsible that the decision be just.